Hi, I'm Emily and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, when can a school disclose information without parental or student consent?
Hi, Emily. This is a key question. Thank you. So the parent and student do not need to consent when the school is disclosing information to state and local officials who are using the records to conduct audits, evaluations, and compliance reviews of specific educational programs. The school can also disclose your students' educational records to organizations that are contracting with the school to develop and administer predictive tests, administer aid programs, and improve classroom instruction. Under the statute, the term organizations include federal, state, and local agencies and independent organizations. Congress has nevertheless imposed some restrictions to ensure that organizations are properly using your child's educational record. First, the written agreement between the school and the organization must specify the purpose, scope, and duration of the studies and information that is to be disclosed, and certain assurances from the organization that it will only use the records for its intended purpose. Second, when conducting the studies, only representatives of the organization that have a legitimate interest in the information can access the records. Finally, once the organization completes the study, it has to destroy or return to the school all personally identifiable information. To ensure that schools comply with these requirements, the U.S. Department of Education has the authority to prohibit an institution from disclosing information to a third-party organization for 5 years if it makes a determination that the school violated the provisions as discussed. If a student is intending to enroll or transfer to another school in a different district, the receiving school may access the educational records from the sending school without parental or student consent, unless there is a board policy prohibiting the transfer of records. However, under both Connecticut and New York law, the receiving school must send written notification to the sending school at the time the student enrolls there. The sending school then has 10 days after the written notification to send all the students' educational records to the receiving school. If the sending school does not disclose confidential information under these circumstances, it must make a reasonable attempt to notify the parent or the student at his or her last known address. However, schools do not have to carry out this notification task if 1, the parent or student initiated the disclosure, or 2, the school specifies a policy in its annual notification of forwarding a student's records to the receiving school when that student enrolls there. In any event, the school has to provide copies of the disclosed records to the parent or the student and an opportunity for a hearing if he or she wants to amend the records. School officials may also disclose information pursuant to a court order or subpoena. In doing so, the school has to make reasonable attempts to notify the parent or student about the order or subpoena in advance of the disclosure, so the parent or student has an appropriate opportunity to challenge the subpoena or court order. On a related note, if the school is defending or pursuing a legal action by or against a parent, it can disclose relevant student records without a court order, subpoena, or prior parental or student consent. Also, the school can disclose student information to state and local authorities without written consent of the disclosure if it's related to the juvenile justice system's ability to serve that student. The school can also disclose confidential information in emergencies if the information is necessary to protect the health and safety of the student or other individuals. Parents should be aware that the school has the statutory authority to disclose confidential student records to teachers and school officials within the school and at other schools if they have a legitimate interest in the behavior of the student. The statute also permits the school to disclose information to any other individual whose knowledge of the information is necessary to protect the student and any other individuals. Finally, the school can also disclose directory information without consent if the provided public notice to the parents and eligible students attending the school. Directory information means any information in an educational record of the student that would not generally be harmful or an invasion of privacy if disclosed. Examples of directory information include the student's name, address, phone listing, email address, photograph, date and place of birth, major field of study, grade level, enrollment status, dates of attendance, participation in activities and sports, degrees, honors, and awards received. The Department of Education has outlined requirements for what type of information must be in the public notice. First, the notice has to contain the types of personally identifiable information that the school has designated as a directory information. And second, the school has to spell out that the parents or the eligible student's right to refuse to let the school disclose such information in the period of time within which he or she has to notify the school. If you have any questions about FERPA and a school district's right to disclose your child's educational records, please feel free to reach out.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at LMacdonald@mylaw.com, and please visit mylaw.com for more information.